Bryan Stevenson, Director of Equal Justice Initiative, and we don't think there's any dispute that sentencing a 13-year-old to life imprisonment without parole is unusual. It's happened only twice for non-homicides, only 9 times. We also think that to say to any child of 13 that you're only fit to die in prison is cruel. And we believe that the Constitution prohibits that kind of punishment and that this court should enforce that in this case and in the Graham case. We're very hopeful that we can create the kind of jurisprudence that sentences children rationally and appropriately. And we concede that some kids are going to have to be punished and have to be sent to prison, but we don't believe that any child, particularly a child of 13, should ever be condemned to die in prison. And we'll wait to see what the court says. Thanks very much.
Mr. Stevenson, the Chief Justice asked a lot of questions about drawing such a hard line and then how do you draw it? And he suggested that you'd be better off, really, than if there were a review to see if each sentence was proportionally, was disproportionate.
Well, obviously, we'll accept relief if the court chooses to implement it in that way. But my big concern is that the kids who end up with these sentences are the poor kids. They're the kids who don't get the kind of assistance that they need. Joe Sullivan had a lawyer that never even filed a single appeal or never filed a single brief. And it's because these kids are poor and disabled. All of the children serving life without parole in this country for crimes at 13 and 14 are African American. And I don't, frankly, believe that the best way to proceed is this case-by-case and individual review, because poor kids and minority kids and disadvantaged kids are always the ones who end up with these harsh sentences. So I think we do need a categorical ban. I hope the court articulates that in this case, and we'll see what they do.
Justice Scalia says all you've really established is that this punishment is rarely imposed. The fact that it's rarely imposed doesn't make it unconstitutional.
No, sadly, there are 80,000 juveniles each year who are arrested and charged with violent criminal offenses. And so the opportunity to impose this sentence is quite available to judges and sentencers all over the country. The fact that we don't impose it, I think, says something about who we are as a society. And we realize that to condemn a child of 13 or 14 or to any juvenile to die in prison is cruel, it's indecent, and cannot be reconciled with our principles and values. And that's what I think that determination reveals.
What about the argument that you don't know what the child's going to become? To make a judgment now about what the child's going to become is impossible. There's an argument you have made of it.
Well, I think that's right. We don't know, but we do know that when we intervene with children, our chance of success is so much greater than when we intervene with adults, which is why we shouldn't condemn children in the way that we condemn adults. My brother colleague is here, and I'll turn things over to him at this point.